Hello, and welcome to video number 5 in our legal environment class for this 4-week period. It's called Discrimination in Employment, and it's based on what you've read about in Chapter 16 to some degree. Now, my assumption is you've read that material and have understood it, but the reason I think this video is important is because the term discrimination has a lot of different legal connotations associated with it. And so I want to make some differentiation in those that I think might in fact be helpful to you. So let's begin. By and large, when we think of the question of discrimination, particularly in regard to governmental action, we're usually talking about discrimination in providing state benefits that are available to all eligible parties, like education, like housing, like benefits. Classic examples include cases like Brown versus Board of Education, where we find that governmental discrimination based on race in the provision of educational services to individuals in the United States is in fact unconstitutional. Now, in these instances, we're talking about the Equal Protection Clause of the 14th Amendment, which provides this kind of constitution. And you saw some discussion of this back in Chapter 4 of your text, where we talked about business in the Constitution. These instances of discrimination generally apply, again, to kind of public benefits that we expect the government to provide to all people regardless. And that you found back in Chapter 4 that the Supreme Court has found that the Equal Protection Clause provides different levels of protection against discrimination and that apply to different classes of people. So they're determined by different levels of scrutiny. So that if you fall into a certain category based on race, alienage, or national origin, a law that is going to discriminate against you based on any of those 3 categories would have to pass what is called strict scrutiny, meaning a very high bar before the government could take any action in any way that would discriminate based on that characteristic. For characteristics involving gender or sex, it's an intermediate, a stricter level of scrutiny, but not quite as strict. And for any other levels of discrimination, the court has usually applied a rational basis test in interpreting the Equal Protection Clause of the Constitution as it applies to discrimination, meaning as long as the government had a reasonable basis for making this decision, that it is in fact constitutional. Again, remember here we're talking about constitutional provisions, not legislative provisions, which we will talk about in a moment. The Constitution provides one level of protection. The government may always provide higher levels of protection in statute, which is often what they have done in regard to discrimination in employment questions. Okay? But I think it's important to make this distinction because back in Chapter 4 we have this discussion about the Equal Protection Clause and protection against discrimination, and here we're talking about something a little bit different. Now, the reality is that while your text spends most of the time talking about discrimination in private employment, which makes sense, the government is also a major employer. Actually, back in 2015, some statistics I found put up by the Bureau of Labor Statistics found that there were almost 22 million people employed in the United States by either federal, state, or local governments. That's a lot of people who are affected by employment considerations. The reason the different levels of scrutiny matter is that whether we're talking about employment or whether we're talking about application of the law to individuals, governments discriminate all the time. If you have a low SAT score, you're probably not going to get into Penn State in comparison to those who have a higher SAT score. That, in fact, is discrimination of a certain kind. Now, it's reasonable, and it's not based on a protected class. It's not based on race, not based on sex, not based on national origin, and so it can be done. But the reality is that the government, in form of Penn State in this instance, is in fact discriminating to some basis, right? However, in race and gender, the bar is much higher before government can take those actions. Now, that's talking about discrimination in general by the government. When it comes to discrimination in employment, the federal and many state and local governments are bound by the same kinds of laws and provisions as apply to private employers that you read about in your text. So while the 14th Amendment Equal Protection Clause theoretically applies to prohibit discrimination in certain forms of government employment, the reality is that the statutes enacted by Congress probably provide greater protection in most instances than might necessarily be provided by 14th Amendment equal protection. So discrimination in regard to benefits into housing, in education, are more likely to find the levels of scrutiny applied in determining their legality as found and discussed in Chapter 4 of your text than are necessarily the case in regard to employment. Now, the employment discrimination in the private sector is where your text emphasizes its work. I would remind you again that all of these laws also apply to those 22 million people who are employed, particularly in the federal government, in most instances in state and local government. And even if the provisions discussed here don't protect state and local employees, they do. Most states have similar provisions in their state law that provide protections to state and local employees. Right? The statutes are important not only because they might provide greater protection than the Constitution provides, but also because the 14th Amendment Equal Protection Clause does not apply to private parties. It only prohibits discrimination by the government. So in all of those instances, in the much employment that we're talking about individuals being employed by private parties, and therefore they're not protected under the 14th Amendment. So both Congress and many state legislatures have enacted numerous pieces of legislation to provide protection against discrimination in employment. Most notable federal laws are detailed in your text, and I'll talk about them quickly here. Title VII, passed in 1964, probably the most prominent and best known, prohibits employment and discrimination based on questions of sex, race, color, national origin, or religion. The Americans with Disabilities Act protects individuals with physical or mental impairments from being discriminated against. And the Age Discrimination Elimination Act protects individuals over 40. For those of us who are substantially over 40, I have trouble thinking of anybody over the age of 40 being old. But in fact, that is who is protected by that piece of legislation. Now, this doesn't mean that an employer cannot not hire somebody who may have those characteristics. An employer may choose not to hire me because I'm 60 years old, as long as the reason they have chosen not to hire me is not because I'm 60 years old, but perhaps I don't have the technological skills, for instance, that may be required by that job. Right? An individual who may be blind may not be able to be employed as a pilot. That may seem like a silly example. I mean, maybe technology will change so that someday that won't be a problem, but today that would be a problem. In that instance, it is in fact the disability that's stopping the individual from being hired, but the employer has a good public safety reason for doing so. So the laws limit how much discrimination can occur, particularly when it's discrimination that is meaningless, meaning it's based just on the fact that somebody is of a different race, is of a different religion, is of a different gender, in ways that will not affect their ability to carry out the job. Right? Laws against discrimination, the ones we just talked about, differ in a variety of ways. They differ in regard to who it defines as being in a protected class. So not every individual necessarily falls within a protected class. People with brown hair aren't necessarily protected, although I don't know of anybody who's not employing people because they have brown hair. They differ in the degree of protection that is provided by the governmental action against the actions of a private enterprise. So each piece of legislation will have a slightly different role for different governmental agencies to play in providing the kind of support that individuals may need in bringing suit against an employer. Each presidential administration and on the state level, each gubernatorial administration will differ in the degree to which it puts resources, both time and money, behind fighting these kinds of employment discrimination, which means that oftentimes the burden of challenging discrimination in employment falls on the individual, who may or may not have the resources to do so. So employment discrimination is more easily challenged when in fact there's a governmental agency who will back up the claims of the individual. That is sometimes more present in some administrations than in others. And finally, they each differ to some degree in the kind of remedy that is provided if in fact illegal discrimination is found, although all of them will probably provide some sort of financial remedy or an equitable remedy allowing for some sort of job reinstatement, for instance, or perhaps in some instances both. Right? The other thing that is really important to bear in mind when we're talking about laws against employment discrimination is that the question of burden of proof is really important in these cases. The burden of proof meaning who has to work hardest to prove their point. The plaintiff, or the person who's affected by the alleged discriminatory act, must show that the action taken was for discriminatory purposes and not some other. I must show that the reason you refused to employ me was because I was over the age of 40, and not because I did not have the skills that were necessary for the job. That can be a very high burden to meet, and a very difficult burden to meet. Once that has been shown, the defendant or the employer then has the burden of showing that the employment action was taken for a non-discriminatory reason. But the initial burden lies on the plaintiff to be able to show that but for the fact that I am over the age of 40, or but for the fact that I'm a woman, I would have gotten that job, or I would have gotten that raise, or I would have gotten that promotion. A difficult bar to reach, and can be aided to a great extent when in fact there are governmental bodies who will help the individual or try to find resolution short of going to court in order to resolve potential discriminatory actions. So I hope this helps to clarify a little bit some of the information that you read in a combination between Chapter 4 and Chapter 16. Thanks for your time.